issue. We have a lot of paper to present and to discuss, to deal with a sort of new beginning, how to manage with a new kind of relationship between the parties of the employment relationship, and not only the work relationship in general, and the machine. It's true that each age has its proper problem and issues, but it is very interesting and curious how the approach of this moment of growth of the technical tools and method and organizational systems is very close as an approach to the one of the people at the beginning of the industrial era. How to manage, how to respect the fundamental rights with respect to the introduction and to the growth of the using of this system in the enterprises and within the work and employment relationship. So some reflection about these general problems will be carried out by our presenters. So it's better to begin with the presentation of the paper. The first paper is the Mariella Giovannone, and that is devoted on the impact of the intelligence, artificial intelligence, on the systems of the protection of health and safety, a human right approach. So, Mariella, the floor is yours for 20 minutes and no more. It's better, yeah, we change our places. Thank you.
Okay, hi everybody. I'm going to share my presentation. Just a few seconds. Fa caldissimo. Okay. Let me share the presentation. Okay, here we go. So thanks a lot, Professor Bellomo. And first of all, let me say, even on behalf of my colleagues, the panelists, thanks a lot for accepting our invitation in being a chair and a discussant in this special panel proposal. So I'm going straight forward into my focus today, and I'm going to analyze a few aspects. So these are very preliminary reflections of an ongoing research. Preliminary reflections on the interactions between AI, artificial intelligence, and the protection of occupational health and safety. And the theoretical prospect, the theoretical framework in which my reflections could be set are those of a very interesting, such an important growing dichotomy in the debate, in the international debate on labor rights as human rights in response to the process of weakening labor, while intercepting new reflections on fundamental rights. So this is not a new methodological approach. This is such an old methodological approach, but it is a reviewed and a renewed methodological approach that is taking on new colors in the frame of sustainability and the digitalization of work. And these evolutionary dynamics centered on fundamental rights are progressively reflected in the EU juridical institutions, which are promoting the rise of human rights as a countervalue to globalization and, above all, to the global digital market and the use of digital tools and artificial intelligence. So I'm going to develop a first part of reflections concerning the link between the most well-known AI Act, so that's the European Regulation 1689 of 2024, laying down an harmonized rule on artificial intelligence, and on the less known but not less important regulation, EU Regulation 1230 of 2023 on machinery, so the requirements of machinery used at the workplace. We have to say that this is such a complex landscape where we cannot apply a simplistic evaluation or approach based on optimistic view or pessimistic view, since this is a complex landscape that requires a more nuanced approach that considers both the opportunities and risk of artificial intelligence. And why occupational health and safety? Because occupational health and safety is maybe unanimously considered as part of those social rights and worker rights, which could be considered as human rights, and over the last few years, even considered like core labor standards, since in 2021, the International Labour Conference recognized the protection of health and safety as a core labor standard, so a very fundamental labor standard in the international scenario. Okay, so if we look at the very general overview of the EU regulation on artificial intelligence, but more generally EU regulation on social matters, we can see that there is a developing more deep-rooted protective attitude, not only in its social legislation aimed at protecting the person, but also the so-called product discipline itself, whose primary focus remains the protection of the single market, the protection of competition in the single market. But this protection of competition in the single market is progressively getting a more ethic and anthropocentric stance. And this is a common aspect to both regulations. So the two aforementioned regulations both belong to the area, to the legal basis of European regulation concerning competition in the single market, but in both cases we can find an ongoing trend towards a more ethical view on products. So looking at the very general objectives of the regulations, it could be summed up into four main points. So to ensure that AI system placed in the market and used have to be safe and comply with existing fundamental rights, legislation, and minimum values, to ensure the legal certainty to facilitate investment in innovation in AI, and to improve the governance and effective enforcement of existing legislation on fundamental rights and safety requirements applicable to AI system, and to facilitate the development of a single market for lawful, safe, and trustworthy AI applications and prevent market fragmentation. So there is an overall need to create a single market for AI that prevails, ensuring at the same time that the related device have to be safe and respectful of fundamental rights and EU values. We can find different references to the European Charter of Fundamental Rights throughout this legal text. We could look at AI systems at the workplace from two main problem frameworks. And we will probably discover that these frameworks are more theoretical frameworks, but not so operational frameworks. Anyway, from one hand, we could look at AI systems as instruments for the work performance. And here we should understand the problematic issues related to individuals' responsibility with respect to the improper use of or misinterpretation of algorithm outputs, and also the particular operation of the duty of diligence and collaboration, the obligation of obedience, professionalism, health and safety, and responsibility for any damage caused. On the other side, so on the employer side, we could look at AI systems at the workplace as instrument for exercising powers and prerogatives. So here, some issues emerge concerning the appropriate exercise of these powers and its limits. So since these powers have to be exercised in a very rational way, non-discriminatory way, and transparent way, and so on. And even issues related to the more specific issue of today's presentation, that is the safeguards to guarantee the protection of dignity, human dignity, moral personality, freedom, self-determination, and health and safety of the individual. So we can say that the use of AI systems may entail risks to fundamental rights. So given this, it's necessary to adopt a system of rules relating to their characteristics, and they must be that must be possessed before they are placed in the European market. That's why the regulation, the AI Act, introduces a risk-based procedural regulatory model and a series of obligations that are put mainly on the providers of AI systems. So the providers of AI systems are the external factors. So the deployer and the employer could be part of this notion of deployer who uses AI systems manufactured by others, remains in a secondary position and functionally dependent on that of the provider. And it has been observed on this point that the regulation adopts a regulatory technique that is partly immediately prescriptive and partly based on the accountability and the prior risk assessment of the obliged party. So we can find on one end the preliminary identification of roles, obliged parties with their respective obligations and responsibilities, and then the parts concerning the more dynamic obligation, a sort of obligation of means. So that is an organizational accountability through the adoption of circular and iterative management process that have been defined by Professor Ciucciovino here today, that ensures control and compliance throughout the entire life cycle and value chains of AI. Why a risk-based approach? Because this approach is typical of accountability systems, identifies the due data process as the most effective tool to ensure the compliance at all the levels, and would also have the ambition of passing the limits of the territorial boundaries of application of prescriptive rules, and it's functional to allow maximum adaptability of the rules to very different business contexts of application of AI systems. So this approach, once again, binds manufacturers and suppliers and is not binding on deployers, but only possibly adopted voluntarily by deployers. And once again, we can say that the employer could be part of the wider notion of deployers. And it's also limited to, this possibility is also limited to high-risk AI systems. So in that case, the producer must have a risk management system, an appropriate data management and governance system, a quality management system to ensure this compliance. So this risk management system requires constant and systematic review and updating and adopts the classic organizational approach, which starts with the preliminary mapping and analysis of risks. And in the monitoring system, the cooperation of the deployer is expected, but not indispensable. So we don't have, once again, a binding obligation on the deployer, but the possibility, an invitation, a sort of invitation to the cooperation of the deployer. So this procedure is strictly linked from a theoretical point of view, but also from an operational point of view, could be strictly linked to organizational obligations in the proper field of occupational health and safety legislation. And that's why, and I'm just anticipating some of my conclusions, that's why, to a certain extent, in order to guarantee stronger effectiveness of this regulation in the field of health and safety, so in the field of social legislation, in the field of working condition regulations, and a better protection of fundamental rights, maybe the idea would be to give an interrelated interpretations and application between AI norms and health and safety norms in order to guarantee a more holistic view to the organization of this system. Anyway, this is consisted with the regulations approach of viewing AI system as a product and viewing AI as a process of managing a relationship between private parties and exercising power over human resources in the background. So on the employer-deployer, are just second-tier obligations derived from the producer, and in any case, mainly for high-risk systems, and just for high-risk systems, which is the link with the second regulation, that is also the previous regulation on machinery. This regulation is such an important regulation in the field of health and safety because it contains all those specific characteristics which the work equipment need to respect at the workplace in order to guarantee a safe use. But once again, we are in the legal basis, so we are in the area of product regulation, not in the area of social rights regulation. And there are so many connections, since it also introduces an obligation to assess risk that takes into account the evolution of the behavior, and it also includes those machines that apply artificial intelligence. So this is an obligation to guarantee the prevention of contact risk, which could potentially determine dangerous situations and even psychic tensions that can be caused by the interaction with the machines. And there is the obligation to adopt some specific protective devices and specific tools to be guaranteed. Once again, all these obligations are put on the manufacturer, on the provider, on the manufacturer, and they are not put on the employer or on the provider as a principal responsible. So on the manufacturer, we can find the design of a specific position of guarantee that obliges them to assess the conformity of the machine. So going to the potential impact of these of this European frame on the Italian regulation of health and safety at work, we should, in my opinion, put some questions on the table. We should put some questions on the table, and we should try to understand how they are going to interact with a very well-established regulatory framework on health and safety at work, and a very well regulatory framework which describes in detail and prescribes in detail the obligations of the employer and the obligations of other external functions, such as the function of the provider, the manufacturer, and so on. So, first of all, we could ask whether this regulatory frame will be perfected if it can guarantee or not a certain delimitation of the employer's preventive obligation while guaranteeing at the same time an adequate level of protection on workers' health and safety. Secondly, whether the massive use of such system necessarily requires new rules, or whether the adaptation of the existing rules also as a result of the jurisprudence interpretation could be considered as sufficient, and if there, and what should be the role played by collective actors and social dialogue and industrial relations and workers' representatives in the enforcement of this new generation protection. So if we look at the interaction of these of these rules with the actual system and the system of responsibilities for health and safety at work in our system, we can say that generally our jurisprudence on these issues is generally inclined to state rigid positional responsibilities in matters of prevention. So reflecting what is the distribution of liabilities between the employer and other actors in the use of machinery. So we could ask if it will be necessary to recalibrate the traditional approach applied by jurisprudence, the criteria generally used in order to design the obligation of the employer, its liability or her liability, the immanence of technology, and which is the role. So in the case of the use of AI, it's not taken for granted that the traditional preventional rules on the external parties to the employment relationship are guaranteed. We have a few specific articles within the Italian Consolidated Act on Health and Safety at Work on this issue. And nor we can say it's certain the application of the criteria for the allocation of liability between these parties. So the Italian legislation extended the duty to respect health and safety to the phases of design, construction, and supply phases of machinery to be used in the working environment, with a specific liability, even criminally sanctioned, of designers, manufacturers, suppliers, and installers. And on this point and on this norm, the Italian jurisprudence has long directed the intersubjective division of liability between these parties and the employer, establishing that if the latter uses a machine that is unsuitable because it does not comply with the regulation in force, with the standards in force, he or she is going to share the final liability with the manufacturer unless the defect is unknown and not recognizable with normal diligence. It means that on the one hand, we have a European frame on machinery and even on machinery, including the use of AI system that puts all the attention on the manufacturer and asking for specific and binding obligations on the manufacturer. On the other hand, we have to compare, and in my opinion, we have to intertwine these obligations with all those more specific obligations prescribed by the Italian legislation on the use of machinery, because we have a clear distinction in the positions of guarantees of all these actors, where in most cases, the employer is in any case responsible, except for some specific cases. I'm going very shortly because I know my time is over. What's the role of the social partners and collective dynamics in these new trends, in these new regulatory trends? It's an interesting role because collective bargaining, as traditionally is supposed to have traditionally in our system a crucial role in the development of occupational health and safety legislations. And it seems to be a privileged instrument even for the provision of more specific model rules to circumscribe or to define the tasks of the various occupational health and safety actors, also by virtue of its possible expansion beyond the boundaries of subordination. So they can play such an important role in defining a new balance between the general obligations coming from the new EU framework and the more consolidated obligations set within the Italian systems of occupational health and safety. So maybe we need to find new interpretational criteria, of course, but I'm pretty sure that all these norms have to cooperate in order to define probably a new system of liabilities and responsibilities. Thank you. Sorry for taking time, extra time.
Well, thank you, Mariella. In carrying out my role of discussant, I will not adopt an approach, a critical approach, but rather I prefer to invite you to clarify some point that could be useful to deepen the reflection about all these new issues. I have three questions that we could hope in a very fast way to deal with. Please, can you go to the page 5 of your presentation? Yeah. Okay, in a very short way, you suggest a distinction between cases where AI systems are instruments for performance of work, or different cases where the AI system are means for exercising the powers of the employer. Do you think that is a very realistic and useful distinction? You start your statement saying if, but it seems to me that most of cases AI system are devoted to both the aims, the purposes. First, second point about the distinction that we can find in the regulation 1689 between the systems that imply an high risk, which are included in the field of application of the regulation, and other systems that could be considered outside the field of the high risk. Do you think that the specific rules of health and safety protection and the general duty of protection of the employee could create some duty, some obligation of the employer also with respect to systems that could be not classified as high risk according to the regulation? Third point, you emphasized the responsibility of the producers and suppliers. Don't you think that this approach could enlighten and to make less effective the area of the employer obligation with respect to the protection of the health and safety, but not only, also with respect to the protection of the in the Italian legislation we could speak about the moral personality of the employee? These are my questions.
Okay, thanks a lot for your questions, Professor Bellomo. Since, as I told you, these reflections are very preliminary reflections related to an ongoing research. And really thank you for your questions, because they are supporting me in putting the light on some controversial aspects and also some aspects to be defined. So coming to the first question very shortly, this distinction that you can see on slide number 5, this distinction is also a sort of dichotomy coming from even from literature that sometimes makes this distinction, but I share your opinion, where this distinction could be probably be made more on a very theoretical point of view, but from a practical point of view, it's really complicated. Could be very complicated to distinguish when AI can be put in within the first or within the second problem framework. This is true, but probably when I wrote down the first problem framework, I was more specifically thinking about the use of AI as machinery to give protection of health and safety. So that specific area of machines maybe based even on the use of AI, strictly useful to the protection of health and safety. So in this notion, maybe we could find probably some practical spaces for this idea, for this notion. But I know from a practical point of view, maybe it's difficult. As for the second questions, yes, the regulations put, as we saw, the European regulations put the obligations, both kind of obligations on the manufacturer side, of course, and they potentially involve the deployer, but potentially, and these obligations are mostly related to high-risk AI systems. So maybe there could be the risk to enlighten the obligation of health and safety, but this risk, in my opinion, could be seen only if we look at these regulations and only if we look at product discipline, generally speaking, as a separated part of the European frame in health and safety. On the other hand, I can say that traditionally, these two sides, social regulation and product discipline at European level and also within the implementation in the multi-level system, have been traditionally linked in the field of health and safety. So in order to prevent and to avoid this enlightenment of obligations, we need, in my opinion, to read, to analyze, and to make a more holistic interpretation of the obligations set up by the regulations on the one hand, but they need to be integrated with all the other obligations set up by the national legislations and by the other European norms. I'm thinking about the European Directive 391 of 1989, first of all. So they need to be integrated, of course, in order to avoid this risk of enlightenment of obligations. Finally, coming to the producer and the employer. So the last question is strictly linked to the second one. Once again, I can say so far our jurisprudence has interpreted the division of these positions of guarantee following the idea that we need to consider the specific position of manufacturers, of the seller, of the manufacturers, but generally the employer is always responsible for all the value chain. And this approach, in my opinion, is going to go on even in the implementation of the regulation. Anyway, a big responsibility is put on one hand on the courts. So on the courts in the interpretation of these aspects, but on the other hand, maybe collective agreements could give some support in defining this area. Anyway, the general principles and the general duty of protecting health and safety has to be considered and integrated, because the general principles and norms of our systems need to prevail or to be integrated with the more sectoral norms set up by the regulations. Hope I've been satisfactory.
Many thanks. I am a bit skeptical about the competence of trade unions to regulate this individual situation and rights. So we have to hurry, and so I invite on the floor Luisa Monterossi for the presentation of her paper on working time and work-life balance from an AI perspective, the role of collective bargaining.
Tanto qui perché c'è qualcosa nel mouse che non va. Devi presentare, aspetta. No, è stata con tutto. Sì, penso di sì, ok. Insomma, sì. Okay, good morning, good afternoon to everyone. First of all, I would like to thank Professor Bellomo for the introduction and for agreeing of being our chair in this panel session. I will focus on the work-life balance, analyzing collective bargaining on the theme and the issue, also in a gender equality perspective. And in fact, as happened in the past, during the technological revolution around the mid-1980s, also the current digital transition has fostered the need for workers to gain more time for themselves. Digitalization, technology, and also artificial intelligence can surely promote the achievement of these objectives. I think almost in two ways. First, by reducing working time, speeding up some production processes. And in this regard, I would like to mention the current debate in Italy as well in other European countries about the possibility to introduce a legislative innovation in order to reduce the normal working time, and the same goal has been achieved in some companies such as Lamborghini, Intesa San Paolo, or Luxottica, with the support of collective bargaining. But the same goal to extend the private lifetime can be realized also by adding new areas of protection within the employment relationship, which can take the form of conciliation measures. So during my presentation, I will focus on two types of conciliation measures, which are work-life balance measures. The first is the Institute of Leave. The second are flexible working arrangements, and basically I will focus on part-time work and agile work, which is the more common Italian form of remote work. I will talk about work-life balance policies in a gender equality perspective, because we know there is a strict link between work-life balance and the gender equality. It has been stressed also by the European legislature, first by the European Directive number 1158 of 2019 on sharing of family responsibilities, but also by the European Pillar of Social Rights, which devotes the ninth principle on work-life balance.
So, coming to the analysis of, before coming into the analysis of collective agreements, I would like to sum up briefly the legal framework, the Italian legal framework on leave, because the institute was introduced in Italy with the law number 53 of 2000, which provided only maternity and parental leave, while the paternity leave has been introduced in Italy only in 2012 with the so-called Riforma Fornero, and now the current discipline provides two types of paternity leave, the mandatory leave and the alternative one. The first amounts to 13 days, which can rise to 20 days in the case of multiple births, and it can be taken by the working father in a period ranging from 2 months before to 5 months after birth. And it's very important, it's covered by full pay and figurative contribution. On the contrary, alternative leave is granted to the working father for the entire duration of the maternity leave or for the remaining part in case of death or of severe or serious infirmity of the mother. And unlike the mandatory leave, it is covered by an allowance of 80% of salary. So, turning into the collective agreements, we can say that its work-life balance policies are typically regulated by collective agreements as well as law. And social players usually intervene in the matter with the two types of measures. First, by improving the amount of the allowance granted for taking leave, and or introducing additional leave to allow employees to devote themselves to family matters. So, I would like to mention here today we have a lot of collective agreements which regulate the issue work-life balances, but I would like to mention the Marchial Agreement signed in 2023, which provides additional leaves, 5 days of additional leaves only for father workers, and they are covered by an allowance equal to 100% of salary. I think this provision is particularly significant because it promotes surely a more equal distribution, a more equal sharing of family responsibilities, also considering that it allows to have a full pay for taking leave. A similar provision is contained in the National Collective Agreement for the toy industry. It provides 2 additional days of paternity leave, but in this case, in my opinion, the effectiveness of the measure is undermined by the fact that if the parents are employees of the same company, the additional paternity leave is an alternative to additional work permits granted to the mother worker, and these work permits amount to 30 continuous calendar days. So, in my view, this provision seems unbalanced against women, because women can count on a longer period of absence, and therefore they will continue to be likely bear by the burden of family instead of fathers. The same National Collective Agreement for the toy industry provides another significant measure, because it provides the recognized for parental leave taken after 2024 the right to an allowance equal to 80% pay for 2 months of parental leave. In this sense, it on one hand, this provision on one hand improves on the rules in force at the time, and on the other hand, anticipates the changes introduced by the recent budget law for 2025. Indeed, we have to consider that upon the discipline in force before the recent budget law, the worker was entitled to an 80% allowance for the second month of leave only for leave taken in 2024. And only the budget law for 2015 have introduced this provision in a structural way. So in this sense, the provision contained in the National Collective Agreement, which had been signed in 2024, anticipates and improves on the rules in force at that time. Moreover, we can also mention the Chiesi agreement, which is a company collective agreement, unlike the national collective agreement for the toy industry, and it provides, it recognizes an allowance equal to 100% of salary for the entire duration of parental leave. So it is an important provision because it should promote the use of parental leave also by fathers, by father workers, because it eliminates the economic prejudice. An economic prejudice which will turn into a pension prejudice in our Italian pension system. Coming to flexible working arrangements, the second type of work-life balance policies. I've already said that I will focus on part-time work and agile work. They are very different from each other because part-time work is based on the reduction of working hours and as well as on the predictability of the working hours. On the contrary, agile work, which is also called smart working, implies the possibility for worker to organize autonomously the performance. And according to what it's established in the individual agreement, the working hour may be unforeseeable. But surely both part-time work and agile work are considered like fundamental work-life balance measures because they have in common the flexibility. But they have also in common the risk, a great risk of marginalization of women, because both may turn into instruments that instead of facilitating gender equality, may undermine it. And the same risk is also stressed by the European legislator in the European Directive number 1158, the above mentioned European Directive on sharing responsibilities. The same directive, on one hand, promote the use of flexible working arrangements such as part-time work and remote work, but on the other hand, conscious of the risk of marginalization and conscious of the need to use in a limited way these two forms of flexible arrangements. In fact, Article 9 of the European Directive states that flexible working arrangements must be subject to a reasonable duration and ensure a return to the previous work-life organization even before the agreed reduction period. Indeed, this provision, this clarification made by the European legislature stems from the observation of part-time work, which over the years, before surely it has proved useful in allowing women to remain in the labor market despite family burdens, has important disadvantages, especially about social implications, because reduced working time results in a lower pay, to which in Italian contributive system, pension system, the amounts of social security contributions to be paid will be pegged. So part-time work, lower pay, and ultimately an inadequate pension payment. This effect has been seen in the past with regard to part-time work, but in my opinion, and also some authors have read the same, the same risk have to be considered also in relation to agile work, because agile work is performed remotely, and it could surely undermine the value of work that leads to emancipation, as we have seen in part during pandemic. So what are the provisions of collective agreements about part-time work and agile work? Part-time work is in many cases, collective agreements provide a priority for access to part-time work for those workers who are parents and use leave to access part-time work. Or in other cases, social players used to introduce a special protection or special schemes or part-time schemes devoted always to workers who have family care responsibilities. Maybe more complex is the discipline introduced by collective bargaining on agile work. First of all, we have to underline the legal framework, Italian framework on the issue, because we have to consider that the conciliation purpose is stressed also in law number 81 of 2017, which is the law devoted to containing the agile work discipline. And in fact, conciliation objective is one of the two goals for which agile work is directly intended. The other objective is the improvement of company competitiveness. But nevertheless, at least in the original wording of the rule, the conciliation allowed by the Italian legislature was not qualified. I mean, there was not a link, a direct link with the work-life balance. Someone in doctrine has spoken of conciliatory aim without adjectives. Nevertheless, the subsequent legislative amendments have introduced a priority for female workers and workers with children up to 12 years of age or without any age limit in the case of severely disabled children and in other cases. But analyzing collective bargaining on the issue, we have to consider that very often social players promote the use of agile work and provide special discipline for workers with family burden. For example, by adding additional working hours that can be performed through agile work, establishing for male and female workers with care responsibilities a more favorable discipline than for the generality of employees. For example, it's the case of Leonardo Society Agreement signed on 2022. Or by providing additional days of agile work, such as we can see in the annual agreement or in the team agreement. Moreover, In other cases, and in particular in the insurance sector, it's provided by the Reale Mutua Assicurazioni Agreement. It's a company-level agreement. It provides the customization of working hours in favor of employees with key responsibilities to enable them to deal with and manage the work-life balance with greater autonomy. So this customization of working time may consist of a reduction of working time or a different distribution of it, or in the possibility to individualize the working hour using the so-called time bank. Time bank is an institute regulated by collective bargaining. It's a sort of virtual account which gathers, rest, leaves, permits that can be used by workers later according to what the conditions established by the collective agreement. Furthermore, we have the Generali Group Agreement. It's very recent. It has been signed in 2023 and expanded in 2024. It allows the regulation of aging work to be remodeled in presence of special family care and assistance needs. For example, it provides the possibility to take advantage of aging work on a fractional basis in groups of 4 hours for a maximum of 2 days per month. Moreover, the company is obliged to facilitate access to aging work for special types of workers who perform activities that can even be partially remote and are in special need. Lastly, it also provides, and in my opinion, it's a very significant provision, 2 additional hours of disconnection. With this measure, the social players, the agreement, social players show the consciousness of the risk of hyperconnectivity, often associated to the use of aging work, and provide a special protection for workers with family responsibilities by reinforcing this connection. Coming to the conclusion, I don't know if I have okay. No. No. I think no, I'm in time.
Few seconds.
Yes. Okay. Coming to the conclusion, what is the state of art in the light of this brief analysis of collective bargaining, recent collective bargaining? We can say that social players continue to play a decisive role on the issue, and we can also note some improvements. For example, in the case of companies which introduce additional paternity leaves or which increase the amount of allowance. In some cases, we've seen that, for example, in the case of Chiesi society, social players recognize an allowance equal to full pay, 100% of salary. But we have also to consider that, unfortunately, we have still non-virtuous situation. There is a recent opinion of Agenzia delle Entrate, which is the Italian body competent, responsible for tax matters, and through this opinion, we have evidence of a situation of a company which recognizes an allowance equal to 100% of salary only for parental leave taken by mother workers. And I think it's very troubling because this provision goes in the very opposite direction of achieving a real and effective gender equality. Moreover, sure, the role of collective bargaining is central, but maybe the responsibility to realize, to achieve the gender equality objective cannot rest solely on social partners, and the legislature must intervene. Why? How the legislature can improve the situation and the work-life balance policies. First, for example, by introducing contributory benefits or tax breaks for companies that promote the use of work-life balance tools, but also by providing adequate public services for the care of the children and dependent persons. In this regard, we have to stress that the recent budget law for 2025 has increased the number of beneficiaries of the so-called daycare bonus, but in my opinion, it's not still sufficient. We know that these type of services for the care of children usually are provided by corporate welfare, but the intervention of the legislature is very necessary in my view, because it could make these type of services available to all. Lastly, the last slide. I think it could be very complicated to envision a reform, a legislative amendment that would bring Italy closer to other virtuous systems, such as Spain or Sweden, where maternity and paternity leave have given way to equal parent leave. That is recognized equally for each parent. In Spain, we have 16 weeks with compensation equal to 100% of salary. A similar provision is contained in a recent collective agreement of the Chiesi I, the above-mentioned Chiesi agreement, which have introduced the so-called congedo di genitorialità, which is a sort of mix between paternity and parental leave, but in my opinion, continues to be necessary the intervention of the legislature. Surely it would be very complex on one end, because it would require a significant cultural revolution that is hampered by a solid tradition in which it's mainly the woman who bears the family burden, and on the other hand, because unifying leave and guaranteeing full coverage would require an excessive effort that could not be sustained either by companies or by the Italian system, especially considering the serious financial situation of the Italian institute responsible for social security. Thank you for attention.
Thank you to Luisa Monterossi. The discussant of this paper is Mariella Giovannone.
Okay, thanks a lot, Luisa. And I just wrote down some notes while reading your paper last few days. And I have just one question, and I will be very, very fast. So you were talking about the relationship between work-life balance, and gender equality, and how the former could have a strong impact on gender equality and even on the eligibility to the certification you mentioned at the beginning. So I was wondering, how do you think that the more recent promotional framework on gender equality might affect a better regulation of work-life balance measures by social players, because you have stressed the role of social partners in this process?
Thank you, Marilla, for your remark and your question. Yes, there is I've said that there is a strict link between gender equality and work-life balance policies. We have to consider that recently the Italian legislature has introduced important legislative amendment on the theme and more precisely on gender equality certification, which we know is a sort of document that certifies the company's compliance with the principles of gender equality. For example, these legislative amendments provide several advantages for company which obtains the gender equality certification. They are, for example, contributory benefits, but also advantages in public funding or in the public procurement process. And because of this role of work-life balance measures, which are surely considered in the analysis made by the competent body which issues the certification, I think these advantages, economic advantages, can surely promote an improvement also in work-life balance policies. And lastly, we can also underline that in order to achieve the certification, the competent body have to make an analysis, a complex analysis of the overall policy, and it requires a monitoring system, and sure it can foster the possibility, the legislative amendments on gender equality certification and the benefits associated to this certification surely can prompt the company to introduce this control system also on the use of work-life balance, for example, the correct use between men and women, and it surely therefore can foster an improvement in work-life balance policies.
Okay, thank you, Lisa. So it will be functional to a better respect of another fundamental right to gender equality. Okay.
Thank you to both. The next paper is presented by Federica Palmirotta, and the title is Addressing Discrimination Risk in Algorithmic Human Resource Management, a Legal Perspective. So, Federica, thank you in advance for your presentation.
Thank you. So, I think that the screen is already shared, but I also will try to get more. I mean,
is it sharing?
Yeah, I think that it is shared.
Okay, yeah.
So I can use this view if it's okay. So let me first introduce myself. I'm Federica Palmirotta, and I'm a research fellow at the Department of Law in the University of Modena and Reggio Emilia. And I also want extremely to thank first, Dr. Giovannone for having invited me in this really fruitful panel session, and also Professor Bellomo that is chairing us, not also chairing us, but also discussing our papers. So my paper and my presentation of today focuses on something that is at the intersection of artificial intelligence and labor rights, namely the discrimination risks in algorithmic human resource management. We all know that this kind of digitalization that has interested the labor law has come across with several positive aspects, of course, efficiency and more even neutrality in some sense, but on the other hand, it entails a lot of risks. in particular in the discriminatory field. And my presentation focuses on the factors that contribute to such risks, and on the other hand, tries to consider and analyze legal pathways to prevent discriminatory risks in algorithmic human research management. In doing so, the literature that I've been considering, of course, is very vast, and in particular in Italy, but not only in Italy, the academic discourses focus on the assessing the adequacy of the anti-discrimination law in preventing algorithmic discrimination by focusing prevalently on the remedial aspect of anti-discrimination law. Everybody know that the strategic litigation on discrimination, and in particular on algorithmic discrimination in Italy, has been really advanced. On the other hand, scholars have also focused on other aspects and other legal strategies to prevent discrimination, leveraging transparency. Dr. Giovannone was, for instance, speaking about the Artificial Intelligence Act, which also takes into consideration transparency and the avoidance of discrimination. This is not the only legal strategy. We also have the Platform Work Directive that leverage transparency and involvement of work representatives, and also so far and so on. A lot of regulation in the latest year are talking about transparency as a legal strategy to prevent discrimination. In my research, I have decided to focus on other pre-existent legislative tools that, in my opinion, could prevent discrimination. To this end, my presentation will be divided in mainly two parts. Firstly, I will try to focus on the insights and determinant factors that may give rise to a risk of the algorithmic discrimination. On the second part, I will focus on the legal strategies that I decided to adopt, which mainly are strategies within the anti-discrimination law that I call activation measures. I refer to reasonable accommodations and also the use of substantive equality principle. But not only these measures within anti-discrimination law, but also prevention duties in health and safety regulation. This will be useful in order to make some conclusion. So focusing on the determinant factors that may cause discrimination, we know that the literature focuses on two main reasons that cause algorithmic discrimination. It could be either a managerial choice that could be either intentional or unintentional, hidden in the opaque nature of the algorithmic, but also it could be caused by structural characteristics of the algorithm. We know that artificial intelligence uses techniques like regression or clustering. These techniques make some groups of workers, and while making group, you can use variables that can be connected with grounds of discrimination, and this could cause an algorithmic discrimination. There is also another very well-known aspect that causes discrimination. This is the algorithmic bias. But what are algorithmic bias? They are mainly systematic errors that could deprive of the signification result, an algorithmic and automated result. This can be caused by systematic bias, but also by human bias that could be inherited in the algorithmic by programmers, and it could also be caused by the representation bias, which happens when the data set that is used in the automated decision-making system doesn't use very accurate and representative and inclusive data sets. This can be, however, algorithmic bias doesn't always cause a discrimination. Instead in legal sense, because discrimination can happen only when the algorithmic bias is linked to a ground of discrimination, because we know that the anti-discrimination framework adopts let's say a taxative framework where only the protected grounds of discrimination are grounds that can be enforced in court. So when in case a discrimination occur, the European anti-discrimination framework is very vast. There are lots of directives, and indeed there's also a problem of not, how can I say, there is not a unanimous regulation on this field, but mainly all the directive adopt a remedial approach because they prohibit both direct and indirect discrimination. But for what I just said earlier, we can say that algorithmic discrimination are not always direct discrimination. This is because it's very difficult, because of the opacity of the algorithm, to say that the algorithm and the artificial intelligence system is directly using a discriminant ground. But more often, indirect discrimination can occur when they are linked to that proxy that I was just saying earlier, if it is linked to a discrimination ground. For example, if a discriminant, a semi-automated system uses the presence at work as a variable to assess the performance of workers, of course, we all know that this variable is indirectly discriminatory for parents or in generally for caregivers. In conclusion, we can say that the anti-discrimination law are conceived mainly with a remedial and retrospective and also victim-centered nature. They have, this individual nature doesn't seem very adequate to algorithmic discrimination, since algorithmic discrimination are collective in their sense. So that's why I try to focus on other legal strategy. And this is a strength that is also gaining ground in the academic discourse, which is the equality by design theory that suggests to leverage the precision and calibration of artificial intelligence to protect by its very design artificial intelligence and ensure equality. In particular, I decided to focus on the activation measures, which are measures that entail, we can say, an active obligation on employer to promote equality. The first measure that I consider is reasonable accommodation, as I was saying earlier, and then also the substantive equality principle. The pros of these two measures is that they relieve the burden and expense of litigation if well implemented. They can realize a systematic change and not only a change which is focused on the remedy of a discrimination that already occurred. And lastly, they also entail a broader participation of the civil society. On the other hand, I also focus on prevention duties, since prevention duties are also focused on the prevention of psychosocial risk, because health should be intended as a comprehensive concept, which entails damages not only on the physical sphere, but also on the social and mental sphere. As regards reasonable accommodation, we know that the Article 5 of the Employment Equality Directive requires employers to take mandatory measures to accommodate the interests and rights of workers with disabilities. I don't want to focus further on this aspect, as I had the opportunity to read the paper of Dr. Lamberti, which will follow my presentation. So I will say very basic things on this. And for what I can say about this measure is that this measure is focused only on persons with disabilities. It is a mandatory measure, which means that, of course, employers have to comply with the requests of workers. Indeed, it mainly have a reactive nature, as also the United Convention on Rights of Persons with Disabilities say. So, this is also, of course, a very important measure to be realized. And there is also this increasing field of assistive technologies that can be really and extremely useful for persons with disability. But as I said, this measure is reactive, it has an individual nature, and it only covers workers with disability. That is why I've tried to go further and search for other measures. In this regard, there is some scholars believe that the ban of indirect discrimination may suggest a duty of care, an active obligation on employers to remove all the obstacles that could prevent an inclusive labor workplace. These measure, of course, is not really a mandatory measure. We can say that the mandatory nature is inherited by the negative restriction. In this case, the beneficiary subject will be all the worker involved, not only in the when they are already employed, but also in the access of markets. The limit, of course, here is the necessity and proportionality test, which can be proved by the employer if he wants to overcome and prove that there has not been a discrimination. And the essential feature of this measure is that it is preventive in nature. It is collective, because indirect discrimination have a collective nature compared to reasonable accommodation. And in my opinion, it also entails some form of involvement of part that are victim of discrimination. Of course, what this should mean in terms of obligation for the employer. In my opinion, this should mean the search for less discriminatory algorithmic system. For example, avoid the use of standardized criteria in workplace scheduling or in performance management in order to accommodate all the potentially discriminatory subjects. Of course, the limit of this measure is that, as I was saying, is that it is inherited by a negative restriction. So it is not really mandatory in nature. That is why I tried to, let's say, inherit the mandatory nature of this measure through the prevention duties in health and safety obligation. This is because, of course, scholars share the idea that health, as I was saying, is connected with the social aspects, and there is a tight link with the health and well-being. So a good work organization is an organization that is not discriminatory of workers. And a lot of studies prove that workers face significant psychological and psychosocial pressures when area of the employment are semi-automated. What are the pros of this measure? This measure is mandatory, and it is not linked to the discriminatory ground as the anti-discrimination law framework is, and of course, it is not even limited to the being a subject which holds a disability. What are of course, I cannot delve into details, and which also have been in some aspects anticipated by Dr. Giovannone. But this measure entails, first of all, an assessment of risks. And the framework directive on health and safety suggests that this assessment should be made taking into consideration vulnerable groups. That suggests that in health and safety, employers should take into account the impact, the discriminatory impact of decisions and also of organization to the worker. The other pro of this measure is that this measure involves workers' representatives that in discrimination are not really involved as a part, let's say, by law. To conclude, we can say that, of course, what I want to argue in my paper is that, in my opinion, the activation measures together with prevention duties, could be really adequate to prevent algorithmic discrimination. This is because they help overcoming the standardization and indifference towards diversity that is typical of algorithmic human resource management. They can compensate transparency through the involvement in the design. And lastly, they have a collective nature, and therefore they address the collective nature of algorithmic discrimination. As regards the legal tool, as I said, I don't believe that we should take into consideration one of them uniquely, because reasonable accommodation have some limitation in terms of objective and subjective terms. Active obligation to remove or prevent indirect discrimination could have interpretative hindrance. On the other hand, duty of care can be really important, but some scholar or even the jurisprudence may not really share the idea that discrimination is very linked to health when the discrimination is not really already in place. Therefore, what the basic conclusion and main conclusion of my paper is that I believe that there should be a cross-fertilization of these normative instruments that, taken all together, can be also reinforced with each other. And I conclude with this, and I thank you for your attention. And that's all.
Thank you so much, Federica. With reference to the content of your paper, I only could make a sort of crossing between a commentary and a question. The sounding of the expression algorithmic discrimination is very seductive. So we could think that all the problems related on with the functioning of the algorithms are linked to the idea of discrimination. But I'm asking you, can we effectively bring any unlawful behavior or consequence related to the functioning of the algorithm within the definition of discrimination? Or maybe we should have better to distinguish between algorithmic discrimination and algorithmic abuses or violation of other individual rights. When we speak about discrimination, we always are thinking about a factor of discrimination that is predetermined, is fixed in advance by the law. But there are behavior based or caused by the algorithm which are provoking some consequences which could be also some consequences of damages, of violation of individual rights, which are not related with the discrimination factors. How to deal and define and intervene of these different forms of unlawful behavior related to the algorithm? That's my cross between commentary and question.
Okay, thank you for your question, which is a really difficult question since the topic of overcoming the strict taxonomy of discrimination is very widely discussed in literature. Of course, the idea that the discrimination comes from an automated system, in my opinion, should give space for policymakers to begin to overcome this strict taxonomy, since, as I was saying before, the opacity will always make harder to prove discrimination, and most of all, discrimination, as Professor Bellomo was saying, in my opinion, actually often turns into an abuse. However, on the other hand, I believe that I really don't have an idea on this, so I'm just making my mind on this field. Of course, I have to admit that my research thesis for my PhD was on algorithmic discrimination. That is also why this topic for me is particularly seductive. Of course, what I believe is that algorithmic discrimination is just a discrimination, and maybe it would be harder to think that a policymaker will extend the concept of discrimination above the discriminatory ground. What I want to stress is that the anti-discrimination framework, I believe, is a really peculiar legal framework that can't, for reasons of protection of also the employer interest, cannot be really extended further. I think that it would be difficult. That is also why I think that we could use this opacity of algorithm and this relation with proxy, as I was saying before, even though sometimes the abuse may not be linked to a discrimination ground, mostly it will be linked to a discrimination ground. For example, the case of Amazon, I don't know if anybody knows that Amazon was releasing an algorithm for screening, and then of course he instructed the algorithm with a curriculum of employer already, of a manager already employed, which were all men. The programmer of the algorithm didn't say to the algorithm to exclude men, but the algorithm learned himself to exclude men, linking this factor to some other factors, such as playing SQ online. We can say so. I think that is why I believe that the assessment should be made in the design aspects. When I take into consideration a screening algorithm, I should assess all the aspects that could have a statistical disadvantage to discriminatory grounds and see if these aspects could be discriminatory in this sense. I don't know if I really have addressed the question, but I hope that I've tried at least.
Oh, in an excellent way, also problematic, of course. So the next paper is the paper presented by Fabiola Lamberti that will expose the issue of the AI and job opportunities for people with disabilities. Thank you in advance, Fabiola.
Okay, thanks a lot, Professor Bellomo, for accepting our invitation to be our chair in this session. I want to explore the correlation between the AI and occupational disability. On one hand, by analyzing the international legal framework, and on the other, by studying the best practice already known with the experimental application currently underway. The aim is to investigate whether technologies based on the application of AI can contribute to the development of new employment opportunity for people with disability. Also by implementing the possible reasonable accommodation outlined by the international regulatory framework. About the regulatory framework aimed at protecting disability in the workplace, we know that the issue of employment and employment of people with disability has been the subject of several important international interventions, which has led us to ratification of internal law, European law, and international convention signed by the United Nations and International Labour Organization. The most reference to the general objective of enhancing and promoting social inclusion by combating discriminating, based also disability appears in goals number 8 and number 10 of the United Nations 2030 agenda, and this agenda aims to ensure by 2030 full and productive employment and decent work for all women, including young people and persons with disabilities. The first relevant document on the issue of the employment integration of people with disability is very old and consists in Convention number 159 of 1983 of the International Labour Organization Convention and Vocational Rehabilitation and Employment, the subsequent recommendation number 168 of the same year is linked to it, which identify the measures of reasonable adaptation to be adopted to support the employment opportunities of people with disability. The definition of a disabled person adopted by the Convention is contained in Article number 1, where it is specified that this term refers to any person with prospect of obtaining and maintaining suitable employment and advancing in employment are substantially reduced as a result of disability. So we have three specific elements: the disability, the substantial difficulty to entering or remaining in the labor market for disaffected, and finally the formal recognition of impairment. The United Convention on the Rights of Persons with Disability of 2006 is part of this international framework and the broader context of the protection and promotion of human rights, as outlined signs the Universal Declaration of Human Rights and confirms for persons with disability the fundamental principles of equal opportunity and non-discrimination. In general, the Convention does not recognize new rights for persons with disability. On the contrary, on the contrary, it tends to ensure that they can enjoy the right recognized for other citizens. A new element in this reference to promoting the availability and use of new technology, including information and communication technologies, with an emphasis in the use of universal design methodology. In the European framework, we have the Directive 2078, in which we can find the concept of reasonable accommodation that is very important in the Convention, and which in the conventional text is defined as the modification and the adjustment necessary and appropriate to ensure the person with disability the enjoyment on an equal basis with others of all human rights and fundamental freedom. The concept of reasonable accommodation is generally defined in the various sources examined so far as including necessary and appropriate modification and adjustment which do not impose an excessive burden. So now we must investigate whether artificial intelligence and its application can help us find a connection between the employment inclusion of people with disability and the need for reasonable accommodation as mandated by law. In recent years, the advancement of artificial intelligence has opened new avenues for inclusion in the workplace, particularly for individuals with disabilities. The South provides several concrete examples of how AI is already transforming employment opportunities for people with disability through assistive technology system, collaborative robots, and overcoming collaborative barriers with speech recognition system, speech synthesis, and high-tech technologies. On November 2023, the Organization for Economic Cooperation and Development realized a report using artificial intelligence to support people with disability in the labor market. In this report, which delves into the dual nature of artificial intelligence as both a potential facilitator to employment for individuals with disability. The report identifies 142 AI-based solutions addressing visual, motor, auditory, cognitive, speech, and mental health disabilities. These tools can be categorized in 4 groups: disability-centric solution providing direct assistance, solutions that modify the work environment to enhance accessibility, AI application facilitating or augmenting existing solutions to improve accessibility, and tools opening new occupational avenues previously inaccessible to individuals with disability. As the OECD report highlights, the benefit of design for accessibility and inclusivity are significant. AI presents a very important opportunity to enhance accessibility, inclusion, and work efficiency, contributing to overcoming many of the barriers that people with disability face daily. AI can also enhance digital accessibility, making it easier for people with disability to access information and online services. For example, AI-powered speech recognition system can automatically transcribe spoken language into text, facilitating communication for individuals with hearing impairments. For the visual impairments, image recognition and environment description application have been developed that help people who are blind or visually impaired to move around independently and access textual information through a narrative voice. Assistive technologies, which are increasingly sophisticated and customized, make it possible, for example, to adopt screen reading or speech recognition software that not only translates speech into text, but can be used to command a device. A notable example is live captioning algorithms, which real-time transcribe speech into text. This solution, AI can make the digital work environment more accessible to people with disability, allowing those with severe motor limitation to use computer without the use of their hand, or the blind or visually impaired to access digital information. AI can also support individuals with physical disability and advanced user interfaces can control minimal movement, so facial and ocular gestures are particularly beneficial for individuals with several physical limitations, enabling them to navigate the internet and utilize digital device with greater ease. Furthermore, AI offers valuable tools for analyzing labor market dynamics and identifying barriers to inclusion. Inclusion data analysts can use AI to identify occupational sectors with high employment potential for people with disabilities by analyzing required skills and job characteristics, evaluate the impact of inclusion policies, and identify areas for improvement. Another crucial aspect of AI is its ability to personalize the work experience to meet individual needs. Machine learning algorithms can analyze data related to work performance and suggest personalized adjustment to improve efficiency and comfort for individuals with disability. Several companies are already using artificial intelligence to support workers with disability. Here are some examples: Microsoft, IBM, SAP. Microsoft have developed tools like Seeing AI, a smartphone app that uses AI to describe the surroundings to blind people. Additionally, Microsoft has integrated accessibility features into its products, such as Microsoft Office, to improve the work experience. IBM, through its IBM Accessibility Program, the company has created various AI and machine learning solution to enhance access to technology for people with disability. For example, they use AI to automatically transcribe audio recording, making meetings and multimedia content more accessible. And also Google have developed new features in Google Workspace to help workers with disability. One example is voice access, which allows users to control the Android device using voice commands. And so we have SAP, with its Autism at Work program. SAP uses artificial intelligence to help identify autistic talent and support to autistic employees in the workplace. So I think that AI as a catalyst for inclusion, because we can classify 4 types of objectives that company utilizing AI technology can achieve to support individuals with disability. We can know easy communication, improve learning opportunities. Everyone should be able to avail of any service regardless of their disability. AI technology can help ensure this inclusivity. For example, just like subtitles let people with hearing impairments understand a movie, Braille helps visually impaired individual read. And then we have promoting an independent lifestyle and connection to the outside worlds. So that we have some challenges because we know that people with disability have the same right to enjoy life and succeed as their professional goals as everyone else. They should be empowered to work independently, communicate across teams, and learn new skills. Despite the opportunities, the employment of AI raises significant concerns related to privacy, inequality, and potential biases. The personalization offered by AI necessitates a particular focus of safeguarding users' sensitive data, to prevent the misuse of information pertaining to disability. It is essential to ensure that the data used to train algorithms are inclusive and representative of the human diversity, avoiding creating systems that discriminate on the basis of the disability. It is also essential to ensure that collected data is used responsibly and that adequate measures are taken to prevent privacy violation. And we have also opportunities. One of the advantages of AI is its capacity to automate repetitive and physically demanding tasks, thereby reducing the need for human intervention in activities that may be difficult or impossible for some people with disabilities. Further, AI solutions already available or under development enable intervention and mitigation of different types of disability: visual, auditory, motor, and cognitive. According to the OECD report, the most frequently cited barrier to interview is the lack of involvement on individuals with disability in the development of AI-based solutions. The adoption of AI solutions for individuals with disability is also hindered by the limited digital literacy and of the target population, or the lack of interoperability between new AI-based solutions and existing hardware and assistive device. But the dominance of industry in AI sector can have profound implications for the direction of the research, influenced by commercial priority. As a result, AI-specific technologies, such as those supporting individuals with disability, may be perceived as less lucrative by the market, leading to limited investments. Public funding and public-private partnership are therefore essential. Governments and public policies play an important role in fostering the development of accessible technologies and safeguarding the rights of individuals with disabilities. Recent years have witnessed the proliferation of national strategies and initiatives such as the European AI Act, aimed at ensuring the ethical and responsible development of technologies by prohibiting the use of AI systems that exploit vulnerabilities such as or disability. Artificial intelligence offers extraordinary opportunities to improve the working condition of people with disability, enhancing accessibility, inclusion, and efficiency. With a careful and inclusive approach, AI has the potential to transform the world of work, creating a more equitable and accessible environment for all, and offering personalized tools to address diverse needs. The use of AI technology can be a tangible tool for the implementation of reasonable accommodation, because we know that an accommodation is reasonable if it achieves the purpose for which it's made and is appropriate and effective for the worker. But this assessment does not consider the cost to the employer, as it's part of the proportionality test. The latter balances the aim of granting equal rights to the interested person concerned with the cost of the means required to ensure that the accommodation does not impose an excessive burden. The proportionality test is based on several factors, including financial cost. Furthermore, since reasonable accommodation allows individuals to enjoy rights on an equal basis, refusal to provide it constitutes a discrimination on the basis of disability. To realize this potential full necessitates a coordinated effort among developers, users, governments, and third sector organizations. Governments and public policies play a crucial role in stimulating innovation and directing these technologies to ensure that the benefits of AI are accessible to all. So, looking at as a way of facilitating employment opportunities for persons with disability, AI should be framed as a matter of equity and in consistency with human rights principles and standards for achieving optimum workplace accessibility and inclusivity. In conclusion, even if AI has immense potential to create a more inclusive labor market for people with disabilities, to fully realize this potential requires synergistic collaboration between governments, companies, researchers, and people with disabilities. Only through joint commitment will it be possible to fully exploit the potential of AI to create a more equitable and accessible world of work for all. All stakeholders must contribute. So, all the described actions require a solid technical and regulatory framework, which is still immature. There is still a long way to go, but through joint efforts and a shared vision, we can build a future where AI offers new job opportunities for all. Thanks.
Thank you, Professor Lamberti. Now, the intervention of the discussant, Professor Giovannone.
Okay, thanks a lot, Fabiola. And I wrote down some notes even reading your paper. And your presentation strongly recalls the role of legislators, but furthermore, the role of the courts in the interpretation of some criteria and principle, among which reasonable accommodation. So we know that the topic is also at the center of European Court of Justice in its interpretation, but I'm much more interested at the moment on the position of the Italian jurisprudence and the way it's going to implement the principle of reasonable accommodation. So recently there were some rulings concerning this issue, and I would like to know something about the position of the Italian jurisprudence on the topic, and to what extent do you think the employer's obligation to adopt these accommodations is going to be in the future and even in the interpretation by the courts, please?
Thanks. The topic of Italian jurisprudence is the notice period. So the maximum period of absence from work due to illness with the right to retain one's position. And recently we have had an order of Supreme jurisprudence, Italian Supreme jurisprudence, that has said that applying the ordinary notice period to employees with disabilities is a form of indirect discrimination because due to the failure to consider the higher risks of these people for such employees as a consequence for this disability. It is necessary to consider the higher risk for this person. And second, we know that the Italian jurisprudence, according with international and European court, as the concept of special protection, because they have said that the disability person have a special protection in the regulatory framework. So
Okay, special protection, so it's a wider concept if compared to reasonable accommodation. Okay, thanks a lot, Fabiola. Very good, and I have no more questions, even because we are eating time.
Yeah. So there have been many few references to the intervention of the collective parties to improve, to boost the protection of the employees with respect of the artificial intelligence risk. So we have to say welcome to Riccardo Maraga that will deal precisely about with this topic, this issue. So thank you in advance, Riccardo. We will listen and watch your presentation.
Thanks a lot. I hope that you can hear me good.
Yeah, maybe a bit loud. Is it possible to increase the volume?
Yes. Is it better now?
It's better. Thank you.
Okay, perfect. So first of all, I would like to say thanks to the organizer of the conference, and special thanks to Professor Bellomo that have accepted to chair and to discuss this panel. As said by Professor Bellomo, in this presentation, I will focus on the relationship between introduction of artificial intelligence systems in the management of human resources and the participation of workers and union representatives. So I will share the presentation. Can you see the presentation?
Yes. Yeah.
Okay, perfect. So, first of all, we can ask ourselves if there is a relationship between introduction of AI systems in the company and participation of workers. I think that the correct answer is yes, because as everybody knows, the introduction of AI in human resource management presents opportunities, but also a lot of risk for freedoms and rights of workers, as for example, the risk of a dehumanization of the employment relationship, the dehumanization of the traditional powers of employers. With reference to the powers of control, there is a risk of a pervasive and continuous exercise of the control over the worker. And the absence of human intervention aimed at humanizing the algorithmic management can lead to a risk for workers' rights, freedoms, and dignity of employees. So for all these reasons, I have the idea that the application of a principle of participation with employees and their representatives in the case in which the employer decides to introduce AI systems is desirable. And we can also see that in the European Union legal system, but also in the Italian legal system, legislator has decided to accompany the introduction of AI systems with the rights of participation of workers. We can say, however, that the level of participation of workers can be very different, because we can have a simple rights to information, so the obligation of employer to inform workers and workers' representatives about the introduction of the AI systems and the features of this system. This is the base level of participation. We can have a right to consultation. So in this case, trade union or workers' representative has the right to be informed, but also the right to obtain a meeting with employer in which they can express their opinion about the AI system and their proposal to improve these systems with reference to the protection of freedom and rights of work. Then we can imagine a stronger level of participation, so a real right to negotiate. In the literature, they speak about the negotiation of algorithmics, so the possibility that trade unions are involved in the negotiation, in the construction of the system. But what are the functions that this regulation entrusts to trade unions? I can see three types of function. A first function is function of control. So we have already seen this function in other legislation. For example, I can imagine legislation concerning collective dismissal. So other case in which the law entrusts the trade union with an external control to the exercise of some powers by the employer. So also in this case, the trade unions and workers' representative can control how the employer would like to use the AI systems within the company. But there is also, we will see, a function of assistance vis-à-vis the individual worker, because the individual worker can decide to access the information concerning AI system with the assistance of trade unions. And finally, we can imagine a function of negotiation of the AI system. Well, the first regulation that we will analyze together is a rule introduced in advance respect to the European Union by the Italian legislator. So the Article 1 bis of Legislative Decree 152, 1997, the so-called Transparency Decree. According to this provision, the employer or the principal, public or private, should inform the individual employer and the trade union representatives in case of use of fully automated decision-making or monitoring systems that have an impact on human resources. This rule has a very broad application because it applies to all the kind of employers, public and private, and also to the principal, for example, in coordinated and continuous collaboration. The first case law that have analyzed this provision has highlighted that the right to be informed, owned by the trade unions, is autonomous from the right of the employer. the employee. And this is very important because according to this case law, the trade unions are entitled to activate, to use the anti-union repression procedure if the employer denies the right to access to the information provided for by law. Another strength of this legislation is that it provides for a dynamic information flow, because the information should be rendered not only before the commencement of the employment, but also in case of any change to the system. And another possibility also highlighted by part of the legal doctrine is the possibility with this rule for a trade union to enter into companies that are not yet unionized, and so to open new spaces for their representation of workers. We have also some weaknesses of this legislation. First of all, it provides for a weak form of participation because trade unions have the right to be informed, but the law does not provide for the right for consultation, for example. And so the risk is, as we have a lot of times seen in case of right of information, the risk is a bureaucratic approach. So the information is rendered, but there is not a real participation of workers in the introduction of AI system. Another recent legislation introduced at European Union level is the so-called AI Act. I can say that this regulation is not a social policy instrument, but is aimed at regulating the internal market. And so it has not a social approach. For this reason, I can say that the role of social bodies and trade unions in this regulation is very weak. But there are some provisions that I think it's good to analyze. First of all, the Article 26 that introduced a obligation of the employer in the notion of the employer. Sometimes we can have the employer. The employer that decides to use high-risk systems of artificial intelligence should in advance inform the workers' representatives. I think that this obligation is absorbed in our legal system by the Article 1 bis that we have already analyzed, because the scope of application of the letter is broader than the scope of application of the regulation, and I think that it includes also this new information right. There is then another important provision that does not create immediately a right of participation, but can open the way to a broader participation of trade unions. I make reference to Article 95, according to which member states shall encourage the adoption of codes of conduct also by employers that do not fall within the scope of application of the regulation, but that decide autonomously, voluntarily to adhere to the regulation itself. Well, in this provision, the European Union legislator specifies that employer can involve in the drafting of this code of conduct also the trade unions. And so in this case, if this provision will be implemented by member state, we can imagine a stronger form of participation of trade unions. So a real organization participation in the drafting, in the construction of the approach that the employer decide to adopt with reference to So the strength of the regulation is the latter. So the potential capability of the regulation to open a real role of trade union in building codes of conduct and management bodies with the employer that decide to implement artificial intelligence in labor relations based on the centrality of the man and the protection of workers' dignity. If this provision will be implemented by member states, so the possible involvement in a real organizational participation of trade unions. The weaknesses, well, it's clear that the regulation introduces only a right of information. Perhaps this right of information is limited to high-risk AI systems, and so it does not apply for all the cases of AI systems, and the regulation does not provide right of consultation or higher, stronger form of involvement of trade union. The last legislation that we will analyze is the recent directive concerning work performed through digital platforms. This is a real social policy measure, and this social nature of the directive is clear reading the recitals and the important role recognized to social bodies and to trade unions. We can highlight different provision introducing a participation, a collective participation right. First of all, there is an involvement of trade union and workers' representatives in the privacy impact assessment that digital platforms are obliged to carry out with reference to the personal data of employees processes by systems of intelligence, of artificial intelligence. Then the second is the principle of algorithmic transparency. So the provision is quite the same of that introduced in Italy by Article 1 bis. So the obligation to inform workers and trade unions representatives about the features of system monitoring and decision automatic system before the introduction of the system, and when a change on the system is applied, or in case of request by worker or trade union. Also in this case, I think that this information obligation is already absorbed by Article 1 bis, also for one important reason. This directive only applies to digital platforms. On the other hand, the Article 1 bis has a broader scope of application because, as we have seen, it applies to all employers, to all the principals, public and private, that decide to introduce this type of systems. Another important provision is the Article 10 of the directive that requires the digital platform, with the participation of workers' representatives, to carry out at least once every 2 years an assessment of the impact of individual decisions made or supported by automated monitoring or decision-making systems of workers. So this is very important, this rule, according to me, because also in this case, the trade union is involved in an assessment on the impact that this system had on the decision made vis-à-vis the workers. And so in this way, the trade union is involved in an organizational type of participation, because the directive provides that if this assessment shows that there was a discrimination through the use of automated systems, or some decision have violated the workers' right, the digital platform should take the relevant measures, as, for example, amend the system, modify the system, or terminate the use of the system. So if the trade union has been involved in the assessment, I think that it can have also the opportunity to make proposal about the change to be adopted in order to avoid the risk of discrimination, of violation of workers' rights. So I think that also this provision can build a stronger role of workers' representatives. And then we have finally Article 13 that include the introduction of system of automated monitoring or decision making in the scope of application of the Directive 2002/14 about the general framework of information and consultation rights of employees. So also this provision, I think, that can lead to an improvement of the involvement of trade union, because, for example, Italy may decide to amend the legislative decree 25/2007 that has implemented in Italy the directive concerning the information and consultation rights, in light with the objective to introduce also this type of matter in the field of the matter in which trade unions should be informed and consulted. Another important provision of the directive is the rule according to which trade unions in the information and consultation procedure may be assisted by an expert of their choice, and the costs of this expert should be borne by the employer in case the employer employs more than 250 employees. So, what are the strengths of this directive? So we have, I think, a systematic involvement of workers, because we have said that there are a lot of participation rights introduced by the directive. There are some provisions that can lead from a mere information approach to an organizational participation approach. As said, also in Italy, the legislation concerning information and consultation rights can be amended in order to host also the consultation on AI systems. And perhaps the legislator can decide to include not only the digital platform, but all the employers. And the possibility of assistance of an expert reveals the fact that European Union legislator is aware of the fact that trade unions should have specific competence and digital literacy to fruitfully exercise the functions entrusted by the law. The weakness of this directive is the scope of work, because it has not a general application, but it applies only to digital platform. Well, some final remarks. I think that this regulation shows that the multi-level system is aware that the introduction of AI makes necessary, or at least desirable, the involvement of workers and their representatives. However, the regulation introduced have a weak approach, because they introduce only information and consultation rights and not stronger form of participation. But there are some provisions that can lead to stronger form of participation. I can understand the position of the European Union, because each member state has different tradition of industrial relation. So we have country with co-determination as Germany, and country in which this type of participation is not a tradition of industrial relation. And so I can understand that European Union has respected the difference between the studies. I think that the challenge for the trade unions of this new generation information rights are several. So first of all, understand that these participation rights can be introduced in our system not only by law, but also by collective bargaining. So a challenge for the industrial relations system. And so final, I would like to highlight that the effectiveness of these rights depend a lot on the digital literacy and the acquiring of skills by the union representatives. Thanks a lot for the attention.
Thanks a lot, Riccardo. A very short question for a very short answer. With reference to the last statement of your presentation and of your paper, regardless of the existence of duties of information and consultation of the workers' representative, do you think that currently trade unions are able, have the competence, the knowledge, the expertise to evaluate the risk related to intelligence, artificial intelligence, and digital platform, and to propose and to maybe start a conflict defending the introduction of some new protection tools, and how they could fill this gap?
Thanks a lot for your question, Professor Bellomo. It's a very interesting question, not easy to answer. I think that at the moment, honestly speaking, I think that at the moment, union representatives has not the necessary skills to fully understand the information, technical information concerning AI systems, and to make a technical proposal to avoid the risk of discrimination, the violation of rights. So I think that it would be very important to invest on the training, and during the lab chain conference held in Roma Tre University in these passing days, for example, a colleague from Germany explained that German trade unions have already considered this aspect and have created within the University of Labor, that is a university completely owned and organized by German trade unions, a specific degree for unionists concerning this aspect. Before that, this can happen in Italy also. I see very proper the provision of the directive providing for the possibility to involve an expert during the negotiation and the information and consultation, in order to give to the trade unions the necessary skills to understand and to proper exercise the functions.
Many thanks, Riccardo. Many thanks for your presentation. We will look forward to read the final version of the papers. So many thanks to all the participants, all the attendants, and see you in the next occasion.